This is the Media Police Post, broadcasting from the Fort Hoff School of Government, Nairobi, Kenya. In this show, we police the state of truth in the republic. And because truth is communicated to us by journalists and analysts, we have made it our civic duty to put it to the test. We advance from two confirmed truths about the media. One, and according to Roger Stone, the media is either lazy or evil, and for the most part, it is both lazy and evil. That is why the truth, their truth, must be put to a test.
And two, that journalism is verified gossip. In fact, what is presented to us as news analysis is gossip that has been verified by journalists. This gossip has to be ground truthed. We will assess the state of truth in what they submit to the Republic, and we will pass verdict on what is true and what is not. For the record, we are not journalists. We are thinkers. We are not lazy or evil, and we do not verify gossip. What we give you is the truth that sets you free.
On today's show, we will discuss ideas that reflect unformed and uninformed opinions, and ideas that made you stupid. Narratives that fell into the cognitive trap of we see things as we are, not as they are. Narratives based on conjecture history, and those that smack of envelope journalism. Karibu AX and Ms. K.
Thank you so much. So, on Friday, at a meeting with Gema elders, the president finally told us why he and his deputy, Arap Ruto, fell out. According to the president, the two men fell out after the DP attempted to impeach the president to service his own political ambition. And in response, Arap Ruto claimed that the president was lying. And the president was lying not because Ruto was innocent, but because he would never be a part of something that could topple government. It seems that Ruto has conveniently forgotten his involvement in the 2009 maize scandal, the 2015 Langata primary land grab, and perhaps worst of all, the 2008 post-election violence. So, in light of Arap Ruto's apparent forgetfulness, today I would like to spell out the Arap Ruto plot to impeach the president. And I believe there was a plot because he had the means, the motive, and the opportunity. In criminal law, means, motive, and opportunity is a popular cultural summation of the three aspects of a crime needed to convince a jury of guilt. Starting with the motivation, this is the reason the defendant had to commit the crime. In our case, Arap Ruto's motivation was the presidency, plain and simple. And this takes us to the means. This refers to the ability of the defendant to commit the crime. And empowered by Article 145 of the 2010 Constitution, Ruto had the means. Article 145 allows an MP supported by a third of the National Assembly, or about 117 members, to make a motion to impeach on one of three grounds. 1, unconstitutional action, 2, criminal action, or 3, illegal or grossly negligent action. So how might any one of these clauses be activated by Arap Ruto? Not by entrapping the president into impeachable offenses, but by making it appear that he is committing impeachable offenses. But how do you do this? You do this by making the president look incompetent. If he is seen to be incompetent, then you can plant the seed that the president has failed to fulfill his constitutional obligations under Article 131(2). This brings his actions within the realm of impeachable offenses, and this takes us to opportunity, whether or not the defendant had the chance to commit the crime. In our case, Arap Ruto had 5 years of opportunities. When the president needed his principal assistant after Watergate, Arap Ruto stood behind him, smiled, and did nothing. When the president needed his principal assistant after Garissa, Ruto stood behind him, smiled, and did nothing. And when the president needed his principal assistant after Maraga nullified the election, costing our nation 1 billion shillings every working hour, Ruto stood behind him, smiled, and did nothing. Could this be how the president was painted, as incompetent and incapable of motivating the action of his own government? Were terror tactics and judicial misengineering used, and if so, we must ask, cui bono? When the president was seen as ineffectual, who benefited? The man standing behind him, of course. I say this because it is not enough to impeach a president by making him look ineffective. His replacement must also look competent, a trustworthy replacement. And in painting the president as incompetent, Ruto succeeded in painting himself as a worthy replacement, simply because he stood back, smiled, and did nothing. And if you do not believe that the use of terror tactics and judicial misengineering would be enough to impeach a leader, remember that impeachable offenses are rarely seen as impeachable when they first emerge. After all, the scandal that took down Richard Nixon, Watergate, began as a rumor of a break-in before it became a story about presidential abuse of power. So, if Arap Ruto had the means, the motive, and the opportunity to impeach the president, what went wrong? When did he fail, and how? Or is the more important question why he tried it all? What does it mean that a man was allegedly so impatient and so untrusting of the democratic process that he felt the need to steal the presidency? Allegedly. What kind of man is that? I will leave that for you to answer.
Tough things there. Well, today I'd like to discuss BBI and the referendum. This Thursday, 31st March 2022, the Supreme Court will finally deliver its judgment on the Constitution of Kenya Amendment Bill 2020, popularly known as BBI. The BBI case is about the interpretation and application of fundamental provisions in our Constitution, questions that need a definitive answer from the highest level of our judiciary, the Supreme Court. The judgment by the Supreme Court this Thursday will be the final decision on the fate of BBI. And in our view, there are only two options available to the Supreme Court, and each of these options will have a different effect on the 2022 general election. Option 1, the Supreme Court could rule that the BBI process of amending the Constitution was unconstitutional, null and void. Or option 2, the Supreme Court could throw out the civil society basic structure doctrine arguments and allow for the BBI constitutional amendment process and the referendum. So, if the Supreme Court rules that BBI is unconstitutional, then its decision will be a rubber stamp of the decision of both the Court of Appeal and the High Court on the BBI matter. If this happens, then the current status quo remains. We remain with a two-person presidency, and both UDA and ODM will wait until the last minute to declare who their number 2, their running mate, will be in this election. But if the Supreme Court allows BBI to pass, then the political landscape will alter significantly. The seats in the presidency would expand from 2 to 5 with the inclusion of the positions of Prime Minister and 2 Deputy Prime Ministers. Mudavadi, Wetangula, Kalonzo would all get political space at the top, and this option is very probable. Remember, the Court of Appeal decision on BBI was not unanimous. Some of the judges had dissenting or opposing opinions on the issues raised. So if the Supreme Court allows BBI to pass, then we would like to hypothesize that the referendum will be held on the same day as the 2022 general election. And if we combine the referendum and the general election, then we should ask ourselves 2 questions. What are the precedents of combining a referendum with a general election? And what are the benefits of holding these 2 events simultaneously? There are several countries that have successfully combined a referendum and a general election. In 1993, New Zealand combined their general election with a referendum to change their electoral system from first past the post to proportional representation. In 2004, the US presidential election was combined with a referendum on same-sex unions. In 2016, Zambia combined their general election with a constitutional referendum to expand their Bill of Rights. Is it doable? Definitely. Combining referendum with elections will save money and increase voter turnout. It will also formalize the unwritten rules of our own Kenyan politics. On the other hand, we should note that in our unique situation, combining the referendum and the general election could be tricky because of the legal timelines of both the election and the referendum. But that is an explanation for another day.
Now, at the end of last week, the prosecution in the ICC case against Paul Gisheru called its last witness and concluded its presentation of evidence. When this started about a month and a half ago, we here made a number of observations, especially following the opening arguments by the prosecution counsel. We took note of the fact that in the first day of trial alone, Ruto's name was mentioned more than 50 times. And this wasn't too surprising, because it served to reveal a key issue at the heart of the Paul Gisheru case, that in fact, Paul Gisheru is merely the face of the trial, and the actual person on trial is Ruto, referred to severally throughout the case as the big man. This especially makes sense when you consider the purpose for which the alleged crimes of witness interference and tampering were being perpetrated. the famous Roman senator, orator, and trial lawyer Marcus Cicero, during his first major public case, famously posed a question which he himself had borrowed. He used the question as a device or a legal test for unveiling the true beneficiary of a crime by seeking to establish who benefited the most. He said, and I quote, "The famous Lucius Cassius, whom the Roman people used to consider the most truthful and wisest judge, often used to say in evaluating cases, who stood to profit? Cui bono? This is the human way. No one pursues a crime without the hope of some profit." End quote. The prosecution used the evidence to demonstrate that what we are looking at wasn't a series of random accusations stitched together, but rather a well-organized machine that orchestrated crimes with the singular purpose of frustrating the ICC case against William Ruto. The foundation for this in jurisprudence is known as the doctrine of joint criminal enterprise, or the doctrine of common design or common purpose. In the last 1 month, the prosecution has been so effective at presenting tens of thousands of pages of evidence and in undertaking the examination in chief of the witnesses that the defense is now struggling and crumbling to respond adequately. So much so that even the judge, Maria Samba, has called them out. A month ago, on the 25th of February 2022, the court gave a deadline by when the defense was supposed to give a clear indication on whether it needed to present any evidence. The deadline for this was 10th of March, 2.5 weeks ago. Up to now, they still haven't done so. And in fact, they requested for 2 more months, arguing that they needed time to go through the prosecution's evidence, examine the quality of evidence, and they needed time to investigate. They basically hoped to decide whether they have a case to present by 16th of May. And if they discover they do, to start their presentation on 30th of May. But the judge in response stated that firstly, the defense didn't even follow the formal, proper laid out court procedure, and he noted that the lack of diligence on the part of the defense by only informing the chamber on the date of expiry of the deadline of its inability to comply with the chamber's instruction. She further stated that the chamber sees no reason why the defense could not have informed it at a much earlier date that it was unable to comply. To the question of needing time to examine the quality of evidence, the court stated that it was unpersuaded by the defense's submission that it must still assess the quality of the prosecution's evidence. Disclosure of all the evidence upon which the prosecution intended to rely upon a trial was predominantly completed on the 15th of November 2021, over 4 months ago. And finally, as to the issue of needing more time to investigate, the court stated that this deviated from the information the defense gave when it informed the court that it expected to complete its investigations by the end of last year, 2021. But because the judge is fair, despite the court's admonition and reservation, the court took into account the rights of the accused, and only because of this, the court granted the defense more time up until the 25th of April. Be that as it may, ladies and gentlemen, when you consider the strength of the case that was submitted by the prosecution, how well structured it was, and how it revealed the makings and mechanisms of the common plan as well as an organized criminal enterprise with a common design or purpose, when you then consider, on the other hand, the lack of preparation by the defense, you can only come to one of 3 possible conclusions. Either the defense is incompetent, which is unlikely. The defense is being suboptimal, which means they could be nested in more than one game. Or finally, they are seriously struggling to defend the indefensible. Thank you for joining us on the Media Police Post. See you next Monday. Journalists, you've been put on notice.